Yes.
Yes.
Wait, please, Your Lordship. My Lord, I'll just ask 2-3 points, my Lord. Lordship will kindly take note of it. My first point is, my Lord, there was no concession from the appellant side. Therefore, the engaged counsel could not have given the consent. And to that extent, we have an oath. There is a specific government in the review petition. So therefore, we do not want any order by concession. If we have a right, Lordship will adjudicate it. If there is no right, Lordship will not enforce it. Number one. Number two, my Lord, assuming, number two, my Lord, the Honorable Supreme Court's order, which I have given the other day.
That PIL.
Yes. My Lord, what had happened, by order dated 9/12/19, a division bench of this court, on the basis of an suo motu PIL, gave a direction to the Deputy Commissioner that all the government land and reserve forest should be cleared from encroachment. So that order was challenged before the Supreme Court, and Supreme Court passed this order, my Lord, at page 2, that each individual claim has to be adjudicated, and if the decision is against the occupant, then they will have an opportunity of seeking legal redress. Maybe civil suit, maybe Board of Revenue, maybe single judge, maybe dividend tax. So, my Lord, in spite of exercise of due diligence, this order could not be placed before your Lordships. So, my Lord, we are not seeking, yes, by means of a review, we cannot seek a rehearing. But if, my Lord, the error is apparent on the face of the records, and the error is of such a nature that no detailed reasoning is required to ascertain it, then it's a domain of review. Now, here in this case, my Lord, all that we are trying to submit is, assuming we are, it's a reserve forest and we are encroacher, but the due process of law has to be followed. Which is that due process of law as envisaged by the Supreme Court in this order has been followed. It has not been followed. Therefore, my Lord, all that we are saying is we are entitled to some procedural safeguard. Fourth, my Lord, heaven is not going to fall if this matter is decided, until then the authorities are directed not to take an action. Because it's not a question of 7 review petitioners before your Lordships. It's a case where about another 1,597 families who have their house and home and heart in the reserve forest. So, a holistic decision has to be taken. In the ultimate analysis, if your Lordship holds that we are encroachers, this is forest land, even then they cannot throw us out. Government has a duty to, my Lord, find alternative land and relocate us. Till that is done, I don't think, my Lord, any coercive measures should be taken by the authority. Last but not the least, my Lord, if your Lordship will kindly come to your Lordship judgment at page 40. Para 9 and 12. In the event of filing their such applications within 28/12/23, the concerned authorities in the state shall dispose of such application of the appellant for allotment settlement of the government land within a period of 60 days, that is within 28/2/24. Now please come to para 12. For those appellants who submit their application seeking allotment settlement of government land Guwahati City on or before 28/12/23, respondent authorities shall not take any coercive action against them for eviction from the said reserve forest till next 60 days, that is up to 28/2/24. Now, my Lord, my humble understanding is, my Lord, para 12 can't be read in isolation. Para 12 has to be read harmoniously with para 9. If we so read, my Lord, what follows in my humble submission is, if the persons who are in the reserve forest or in the government land make an application before 28/12/23, then their cases will be considered by a 28/2/24 that was yesterday. And till that, there was a direction that no coercive measures should be taken. Now, my lord, it is an admitted position that on 27/12/23, the applications were filed. Now, till that, my lord, nothing has been done. So whether, my lord, assuming, my lord, this judgment stands, even then in terms of para 9 and 12, till such time our cases are considered, maybe rejected also. Consideration does not mean favorable consideration. Even if it is rejected, that's a different issue. But if they're rejected, in that case, my lord, the Honorable Supreme Court judgment in that PIL will spring into action. So these are the 5 points on which I am seeking review, my lord. It's not a case where I'm trying to, I'm taking half an hour time of your lordships to find out what is the error apparent on the face of the records. These are our submissions, my lord, and lordships will pass an appropriate order taking note of these 5 submissions. That is my humble submission. With the lordship's kind permission, can I?
My lord. My lord have seen, my lord. Yesterday was the last day, 28/2. 60 days they have to make an application. And if that is done, they will not be evicted till yesterday. So, my lord, if now they have come up on review, my lord. They file a review. They say that there was some error apparent on the face of the record, though they have failed to indicate which is the error apparent on the face of the record. But if they were aggrieved by the order, passed by your lordships in the writ appeal, they could have immediately preferred an SLP before the Honorable Supreme Court. They agreed before your lordship, that agreed order was passed. On the basis of their agreement and that order, they proceeded, my lord, they submitted their representations for settlement of land. When it was taking time, it was not being done. Now they say the order was bad. If the order was bad, why you have preferred an application for settlement of land under the land policy? You should have immediately gone to an Honorable Apex Court, my lord, challenging the order. Because review, it is a settled proposition of law, cannot be a case of rehearing, my lord. It's not an appeal in disguise. So they have waited.
Can you show us any such application filed by the appellant?
My lord.
359 onwards.
359, my lord. But they agreed not before your lordship, my lord. Pursuant to your lordship's order, they proceeded on the basis of the judgment passed in writ appeal. When they could not get the land settled in their favor, now they agreed. If that cannot be a ground for review, my lord, page 359, prayer for grant of settlement of land. They have made specific reference to common judgment, my lord. Reference number 3, my lord, has seen 21/12/2023 passed in writ appeal number. So from 21/12, my lord, till 27/2, more than 2 months, my lord, they were happy with the order. They made applications in terms of the order. Now they say the earlier senior counsel was not authorized to make that concession. But if that is allowed to stand, my lord, everybody in every case, my lord, instead of preferring an appeal, will change the lawyer and will come and say the earlier lawyer was not authorized. So they were all along in agreement. They were happy with the order. That's why, my lord, yesterday I made a submission, my lord. But they basically wanted to ascertain that the settlement is made in their favor. Till then, they should be allowed to remain inside a forest. There is no dispute made by the petitioners that they are not occupying a forest land. They say agreement was not with consent. They have not said that we are not occupying a forest land. With all boldness, they can say that we are inside a forest land, violating the Forest Conservation Act, violating Assam Forest Regulations, violating Forest Rights Act 2005. 3 laws are being violated by them. And now they say they are to be settled. Now, my lord, on the plea of my lord, the Honorable Apex Court order of 2000 arising out of the PIL of this Honorable Court, my lord. It has been said, my lord, it has been submitted that each and every individual claims are to be decided. But it has not been submitted, my lord. On what context, my lord, the PIL was filed? PIL was filed because some of non-tribal persons were occupying tribal belt land. That was in the context of a tribal belt land, which is protected by some executive instruction of the government, my lord. Here, my lord, these are forest land. This was the order passed by your lordships in the PIL, my lord, against which that SLP was preferred. My lord, I'd like to take your lordship to the PIL, that PIL, my lord.
His Lordship Justice Julia, as was then, was there.
My lord. So that Honorable Apex Court judgment has no bearing whatsoever on the present proceedings, my lord. That was in the context of a tribal belt land occupied by non-tribals. Otherwise, my lord, land was meant for human being. This is a land not meant for human being. This is a forest land, my lord. Well, on the issue of permissibility of my lord, my lord. Continue.
Yes,
My lord, the judgment of the Honorable Apex Court in the context of our PIL, as I have said, my lord, it was in the context of a, my lord, tribal bill land occupied by non-tribals. Honorable Apex Court has held that every individual claims are to be examined, my lord. In the, before Honorable Single Judge, my lord, in that proceeding, my lord, Honorable Single Judge has identified, my lord, each and every claim, tried to examine each and every claim and came to this conclusion that some of them are residing in government land, some are in forest land. It's not that the Honorable Single Judge has not gone into that aspect. That is why, my lord, I made a statement before your lordship in the writ appeal that allowing the petitioner to prefer a civil suit will not be justified because the Honorable Single Judge has gone into the merit of each and every claim and has come to that conclusion. If so, my lord, that Honorable Supreme Court order of examining every aspect, my lord.
plus one thing.
My
There was
lord.
a committee constituted.
My lord.
That committee looked into these aspects.
Yes, my lord.
And with regard to each of the persons who are occupying land,
My lord.
because there are two parts, one is the government land, one is the forest.
My lord.
So thereafter, they found that these are the persons who are occupying the forest land and these are the persons who are occupying government land.
My lord.
So that report was placed before the court by way of an affidavit.
Affidavit.
And the learned single judge, while considering this aspect and while giving the final direction,
My lord.
made two parts. One part is for those
Who are occupying government land?
government land and giving that time.
Yes.
Till such land is allotted, they will occupy that land,
Exactly.
which was not a part of the judgment with regard to the persons who are occupying the forest land.
Exactly, my lord. That was gone into, my lord. So that
That the individual claim of the petitioners who are occupying the forest land, who are before us now in the legal petition, that has been considered and
yes, my
the
lord.
committee has passed that order. Can you show us that copy?
Yes,
Which was considered by the honorable single judge.
my lord.
Because you know that part that there are different affidavits filed by the
My lord.
revenue authority, the
Chief Secretary.
and the forest department.
Yes, sir.
But the two reports, I think somewhere it was there.
Yes,
that
my
it
lord.
has been, they considered were found to be.
Paragraph 18, my lord, may kindly paraphrase. Paragraph 18 of the
Single bench.
single judge's order, my lord. Page number maybe 6. 59, my lord. In fact, my lord, from
Paragraph 15.
18, my lord, after
Yes.
considering the reports, my lord. Although 15 petitioners have jointly filed both the writ petitions seeking appropriate directions that they should not be evicted from the land in their possession, but in view of the facts which have come into light, the preceding facts, my lord, pursuant to the field verification, the petitioners can be divided into two groups. One set are those petitioners who are in occupation of reserve forest land and the others who are in occupation of government land. This court finds it relevant at this stage to note that the payment of Tawzi Bahira is, as claimed by the petitioner, is nothing but a penalty paid for illegal occupation of government land, and the same would not confer any right upon the petitioners to claim rights over the lands under their occupation. In the similar vein, assessment made by Guwahati Municipal Corporation for holding of the temporary and permanent structures constructed by the petitioners and being allotted holding numbers, or for that matter, the Assam State Electricity Board or presently APDCL providing electricity connection to the petitioners cannot, in the opinion of the court, confer any right upon the petitioners over the land under their occupation. In the backdrop of the above, let this court therefore take into consideration the right of the petitioners who are possessing lands within the reserve forest as well those who are occupying government lands other than reserve forest. So their claim of having title or claim over the land based on APDCL, based on GMC, everything has been decided, my lord, considered. Petitioners occupying land within reserve forest area. To understand the right of the petitioners who are in possession of the reserve forest land, this court finds it relevant to take note of the provisions of Assam Forest Regulation 1891 and more particularly Chapter 2, In terms of section 4 of the regulation, the state government is empowered to constitute any land at the disposal of the government a reserve forest in the manner provided in chapter 2 of the regulation. In terms of section 5 of the regulation, when the state government proposes to constitute any land a reserve forest, a notification would be published in the official gazette, specifying as nearly as possible the situation and the limits of such land, declaring that it proposes to constitute such a land a reserve forest and appointing an officer who would be called a forest settlement officer to inquire into and to examine so and so. This was, my lord, that forest regulation was taken note of. Then next paragraph, my lord. How the forest settlement officer will proceed, my lord. Paragraph 21. Paragraph 22, my lord. These are all regarding, my lord, declaration of a reserve forest. Paragraph 24, my lord, may kindly come now. Section 17 of the regulation is very pertinent, which stipulates about the notification declaring reserve forest. And in terms with section 17(2), from the date so fixed in the notification, such forest shall be deemed to be a reserve forest. The records therein would show that final notification under section 17 of the regulation was issued on 1989 in the present case, my lord, whereby 70 hectares of land within the boundary described as mentioned in Schedule B to the said notification were declared to be reserved forest from the date of publication of said notification. This court finds it very relevant to take note section 18 of the regulation, which stipulates that right in respect of which no claim were preferred under section 6 and the existence of which no knowledge have been acquired by the inquiry under section 8 shall thereupon be extinguished unless before the publication of such notification under section 17 of the regulation, the person claiming them had satisfied the forest settlement officer that he has sufficient cause for not preferring such claim within the period fixed under section 6. Therefore, from a perusal of section 18, it is clear that if no claim has been preferred under section 6, and after publication of such notification issued under section 17, there shall be absolute extinction of such right which were not claimed. Section 21 of the regulation stipulates that no right of any description shall be acquired in or over a reserve forest except by succession or under grant or contract in writing made by so and so. That, my lord, forest conservation act was also taken note of. Section 2 is very relevant, my lord. Because, my lord, that all TN Godabaran judgments proceeded on the basis of Forest Regulation Act, my lord. Forest Conservation Act. This court finds paragraph 27, my lord. This court finds it relevant to at this stage to take note of provisions of Forest Conservation Act. In section 2 of the Act of 1980, there is a ban even upon the state government or other authority for de-reservation of a reserve forest without prior approval of the central government. Section 2 of Act of 1980 being relevant is quoted herein below. Restrictions on de-reservation of forest or use of forest land for non-forest purpose. Notwithstanding anything contained in any law, any other law for the time being in force in a state, no state government or other authority shall make, except with the prior approval of the central government, any order directing subsection 2, my lord, that any forest land or any portion thereof may be used for any non-forest purpose. So without the prior concurrence of central government under section 2, no forest land can be used for non-forest purpose. That is why, my lord, all these mining lease, for example, coal mining, the concurrence of the central government is required, my lord. State is the lessor, my lord, but concurrence from the central government is required under FC Act. What I was on, my lord, actually every claim were taken note of by the Honorable Single Judge, clubbing them into different categories based on the reports of the state. None of those reports were challenged, my lord. Reports prepared by the state were not put to challenge, they are accepted. And in fact, if my lord peruses paragraph 40 of the single bench judgment,
40,
my lord, 40. As now they are saying, before the writ appellate court, before your lordships, there was consent without, my lord, instruction. Paragraph 40, my lord, may kindly see. This court, during the course of hearing, was of the opinion that 60 days time be given to the petitioners, petitioner number so and so, from the date of judgment to vacate the land under their occupation. However, Mr. Nath, learned senior counsel appearing on behalf of the petitioners, submitted that petitioners number so and so be granted 90 days time from today on the ground that it will be difficult for the petitioners to vacate their land under their occupation within a period of 60 days. In view of such submission, this court, in the interest of justice, grants 90 days time from from today to the petition number so and so to vacate their land under their occupation, failing which the respondent forest department shall be at liberty. So, my lord, before the honorable single judge also, they say allow us more time, we will vacate. So they consented to vacate the land by 90 days instead of 60 days that was initially proposed by this honorable court. So that was partly an consent order, my lord, as regards their tenure of vacation is concerned. Then they preferred writ appeal. They are also a consent order. Now they say all those consents were based on no instruction. Tomorrow, my lord, there will be second review. They will say the senior counsel presently representing was not, my lord, instructed to give consent. That will be a never-ending business, my lord. Now, if I may take your lordship to two small judgments, my lord. Here 1997, volume 2 SCC, my lord. I'm sorry, my lord. Before that, my lord, just one act, my lord. Forest Rights Act, my lord. Forest Conservation Act, Section 2, my lord, I have already read from the paragraph, my lord. Non-forest activity is not permissible. Forest Conservation Act. Now, my lord, these are the two only acts under which some accommodation can be made. For example, Forest Conservation Act, my lord, with the scheduled caste and scheduled tribe traditional, scheduled tribes and other traditional forest dwellers, recognition of forest right, 2006.
From borders.
Scheduled tribe and other forest, traditional forest dwellers.
If my lord is taking up this book, my lord, page 232 of that book, my lord. 232.
Border.
Yes, yes, please.
But my contention would be, my lord, that only under two statutes, my lord, some non-forest activity or occupation is permissible. One is Forest Conservation Act, that is with the prior concurrence of central government. And this is the Scheduled Tribe and other traditional forest dwellers recognition of forest right 2006. If my lord peruses, there are two categories of persons who were, my lord, bestowed with some rights under this act. Number, my lord, kindly see section 1, sorry, section 2, subsection C. Forest dwelling scheduled tribes means the members or community of a scheduled tribes who primarily reside in or who depend on the forest or forest land for bona fide livelihood needs and includes the scheduled tribe pastoralist communities. Petitioners do not claim that they are scheduled tribes, so they do not come under this definition of forest dwelling scheduled tribes. And the next permissible occupiers are, my lord, O, 2O. My lord. That is, my lord, other traditional forest dwellers. Means any member or community who has for at least 3 generations. 2O, my lord, definition. At least 3 generations prior to 31/12/2005 primarily resided in or who depend on the forest or forest produce for bona fide livelihood needs. My lord, keeping aside their dependence on forest for bona fide use, my lord, if we see 3 generations till 31/12/2005 are to be dependent on forest. My lord, will kindly see the explanation just below that, my lord. For the purpose of this clause, generation means a period comprising of 25 years. So, my lord, if we go 3 generations, 25 into 3, 75 years. Till
Prior to December 2005.
Yes, up to December 2005, they have to go back to, my lord, 1930. So they have to establish that since the year 1930, their predecessors were occupying, the parents were occupying the forest land for bona fide forest
This
purpose.
submission you made it while the matter you heard in division bench.
Yes. Page 15 of the, page 15 of the review petition, madam, for a moment, just one line, page 15. Paragraph 2 of the review petition at page 15. The review petitioners are part of the original writ petition who had filed the above writ petition registered as so-and-so seeking relief from the proposed prospect of imminent demolition of their houses and eviction from their plot of land, which they had been occupying at village so-and-so under so-and-so during the period 78 to 85. Admittedly, after 1930, 78 to 85. They say, if you don't dispute, so they are also not protected under the Forest Rights Act 2005. Now, my lord, on the 1997 3 SCC, my lord, sorry, 2 SCC, page 267. This is that famous T.N. Godavaran case, my lord. One of the judgments, my lord. That case is still pending. 1997, volume 2 SCC, 267. Paragraphs would be, my lord, 4 and 5.
Yes, please.
Paragraph 4, my lord. The Forest Conservation Act 1980 was enacted with a view to check further deforestation, which ultimately results in ecological imbalance, and therefore the provisions made therein for the conservation of forest and for matters connected therewith must apply to all forests, irrespective of the nature of ownership or classification thereof. The word forest must be understood according to its dictionary meaning. This description covers all statutorily recognized forests, whether designated as reserve, protected, or otherwise for the purpose of Section 2(1) of the Forest Conservation Act. The term forest land occurring in Section 2 will not only include forest as understood in the dictionary sense, but also any area recorded as forest in the government record, irrespective of ownership. This is how it has been understood for the purpose of Section 2 of the Act. The provisions enacted in the Forest Conservation Act for the conservation of forest and the matters connected therewith must apply clearly to all forests, so understood, irrespective of ownership and classification thereof. Then, my lord, skipping to paragraph 5, my lord. We further direct as under. Number 1, in view of the meaning of the word forest in the Act, it is obvious that prior approval of the central government is required for any non-forest activity within the area of any forest in accordance with Section 2 of the Act. All the other ongoing activity within any forest in any state throughout the country without prior approval of the central government must cease forthwith. It is therefore clearly that the running of a sawmill of any kind, including veneer or plywood mills, and mining of any mineral are non-forest purposes, and they are therefore not permissible without prior approval of the state central government. Accordingly, any such activity is prima facie violation of the provisions of the Forest Conservation of 1980. Every state government must promptly ensure total cessation of such activities forthwith. So, any non-forest activity, that was a case of mining. There is a case of people residing inside a forest. That is also a non-forest activity. Then there is one more order of T.N. Godavaran, 2002, volume 10 SCC, 2002, volume 10, my lord. Page 634. The bar created by this order is extreme, my lord. Paragraph 3. Issue notice to the, this is, I have checked, my lord, this order is still in force. Issue notice to all the respondents. In the meantime, we restrain respondent number 2 to 32 from ordering the removal of dead, deceased, dying, or wind-fallen trees, driftwood and grasses, etc. from any national park or game sanctuary or forest. In fact, citing this judgment, my lord, we could resist a petition filed for, my lord, collection of forest produce inside National Wildlife Sanctuary of Burha Sapori, my lord. When the eviction was done, my lord, persons therein residing earlier, my lord, they preferred an application before the Honorable Court asking them to, allowing them to, my lord, collect the, harvest the cultivation, my lord, paddies, that was refused, my lord, because of this order.
Justice,
SK Medhi, my lord.
no, prior to that, there was a division bench judgment. Justice YP and Justice PK Shakya.
My lord.
There is a division bench judgment where this claim was rejected by division bench.
Exactly. So not even a, my lord, fallen wood, my lord. Wind fallen tree, my lord. Wind fallen tree can be taken out from a forest, my lord. These people are, my lord, have constructed our residence, my lord. And my lord, on the permissibility of review, 2 paragraphs of a judgment, my lord. 2013, volume 8 SCC, my lord. Page 320. Two thousand 13, 8 SCC 300.
Page
320, 320, sorry, Mel. 320, paragraph 13 to 20. Eight also, my lord. 8 and 12. Well, I'll slowly read paragraph 8, my lord.
just a minute. You are reading 8.
Paragraph 8, just to indicate what was the issue before Honorable Supreme Court, my lord. The only point for consideration in this petition is whether the review petitioner has made out a case for reviewing the judgment and order dated 6/7/2012 and satisfies the criteria for entertaining the same in review jurisdiction. Paragraph 12, my lord. This court has repeatedly held in various judgments that jurisdiction and scope of review is not that of an appeal, and it cannot be entertained only if there is an error apparent on, can be entertained only if there is an error apparent on the face of the record. A mere repetition through different counsel of old or overruled arguments, a second trip over ineffectually covered argument grounds, or minor mistakes of inconsequential import are obviously insufficient. Precisely the same case, my lord. Then paragraph 13, my lord. I'm not taking your lordship to the judgment, those were, my lord, referred to by the Honorable Supreme Court, the observation of this judgment, my lord. Paragraph 13. In a criminal proceeding, review is permissible on the ground of an error apparent on the face of the record. A review proceeding cannot be equated with the original hearing of the case. Paragraph 14, my lord, now. Review of an earlier order cannot be done unless the court is satisfied that material error manifest on the face of the order undermines its soundness or results in miscarriage of justice. Paragraph 15. An error which is not self-evident and has to be detected by a process of reasoning can hardly be said to be an error apparent on the face of the record, justifying the court to exercise its power of review. The review is by no means an appeal in disguise, whereby an erroneous decision is reheard and corrected. Finally, my lord, at paragraph 20, my lord, summary of the principles were made. Paragraph 20, my lord. Thus, in view of the above, the following grounds of review are maintainable as stipulated by the statute. 21. When the review will be maintainable. Discovery of new and important matter or evidence which, after the exercise of due diligence, was not within knowledge of the petitioner and could not be produced by him. Here, my lord, petitioners are contending that the judgment of the Honorable Apex Court could not be placed before your lordship in the writ appellate forum. But that judgment has no application, as I have already indicated, my lord. It was in the context of a tribal well land, and my lord, therein the direction was to consider every individual claims Because my lord, in the PIL, there is no such consideration. But here, my lord, before Honorable Single Judge, all claims were adjudicated based on government official records, my lord. Number two, mistake or error apparent on the face of the record. So there is no mistake. They say only mistake is that, my lord, the consent or agreement of the council was not backed by any instruction. They made a consent before the Honorable Single Judge also. Three, any other sufficient reason. The word any other sufficient reason has been interpreted in so and so case to mean a reason sufficient on grounds at least analogous to those specified in the rule. So sufficient reason cannot travel beyond the prescribed rules, my lord. Now 20.2, when the review will not be maintainable. All these grounds are attracted here, my lord. A repetition of old and overruled argument is not enough to reopen concluded adjudications. That is what they are doing, my lord. Minor mistakes of inconsequential import. Review proceedings cannot be equated with original hearing of the case. There cannot be any rehearing. 4. Review is not maintainable unless the material error manifest on the face of the order undermines its soundness or results in miscarriage of justice. A review is by no means an appeal in disguise, whereby an erroneous order is reheard or corrected but lies only on patent error. The mere possibility of two views on the subject cannot be a ground of review. And the error apparent on the face of the record should be an error which has to be fished out and charged, which answers. The appreciation of evidence on record is fully within the domain of the appellate court. It cannot be permitted to be advanced in the review petition. Review is not maintainable when the same relief sought in the time of at the time of arguing the main matter had been negativated. They challenged the Honorable Single Judge order. They wanted to remain there, but it was rejected. And most importantly, my lord will kindly see, they have accepted your lordship's division bench order. They continued, my lord, they made application. They waited at the on the eve of the last day, my lord, they preferred this review. That means all along they were happy with the order passed by your lordship. Only because settlement was not granted in their favor, they are not happy. So basically, they want to ascertain that they will remain there till the settlement of land is made. At conclusion.
Chief, the instruction is that when learned senior council, whatever he has reiterated, that is.
Tell us one thing.
Relevant.
Yesterday we asked you whether you have filed any reply to the affidavit in opposition and additional affidavit of the respondent number 7. Did you file? Because here you have not annexed anything. You have already annexed the reply to the affidavit.
Yes, sir. That is the instruction is that it
You have not filed.
we are not filed.
Have you ever seen what materials are there in those two additional affidavit in opposition and additional? Have you ever seen?
Lordship, to be honest,
Because you have received both the affidavits, it's been here only,
It's annex.
257 and 266. The clear details are there. Initially, there was a proposed reserve forest.
28
And in the proposed reserve forest, they have issued the notification, gazette notification. Pursuant to which objections were filed, it was considered, the place where it was considered, all those persons were having any objections, and it was settled.
Yes, in the school.
Everything is there, and that is why the Lalit Singhal judge have clarified that how to settle these things, and once the notification is published, then there is no right. And prior to the issuance of the notification, declaring it a particular place as a reserve forest, whatever is to be followed is required to be followed. And here is an affidavit shown by the concerned DFO that when it was declared as a proposed reserve forest, white gazette notification, and what had happened, how they have considered the such objections. And then ultimately 1989, it was notified to be reserve forest. Right? You have not filed any reply to all these, probably. We have also checked the original.
No, it's not there.
It is not there. Then it was in an additional affidavit filed by the same respondent. Officer is different, maybe, but there also they have clarified in what process since the 1968, for example, when the proposed reserve forest was made and how the notification came to ultimate in the 1989. There is nothing before the court to consider that. Okay. Fine.
To identify area, guideline.
Mr. Goswami and Mr. Efra, what is this thing that thinking of fixing the matter for passing of the order tomorrow at 4 o'clock. But today evening we have a program here. We'll pass we'll fix the matter on Monday at 2. We'll pass the order.
Monday, I had some difficulty in my.
Doesn't matter, we'll just pass the order. Otherwise, we'll try to finish it by today itself. But difficulty is since we don't know when that will be over, thereafter we have to see. So order may not be. And madam has a long list.
In fact, yesterday, my lord, so there was no order. I have already informed AFO not to act.
No, it's
Yes,
nothing to do
subject.
like that. We'll pass the order on Monday at 2. We'll pass the order. Monday. List. Monday.
Fourth. Monday,
Okay.
fourth.
We'll sit for the passing of the order at 2 p.m. It will have no consequence to it. Actually. No, I guess if you answer that, I will just.
Item number 3.
Melody as per Lachoda Melody, LCR was called for Melody. Same was not been listened.
So, but it's not bad. Steve's very good. Kali ako, very good. Very good. No, no, that's part of it. Where is the office note? There are 26/02/2024. In spite of issuance of reminder, the record of the FT case number such and such was called for reference tribunal past Moregaon something by order dated 21/06/2009. Thereafter, pursuant to our orders, there is 02/02/2024. Reminder was also issued to the concerned foreigners tribunal on 07/02/2024. issue fresh reminder to the concerned furnace tribunal number 125. Next on. Twenty-first. Failure on the part of the furnace tribunal. Such and such. To provide the records of FTC case number such and such. Dispose of in such and such. The court shall consider to pass consequential order. Against the concerned member, furnace tribunal such and such. As the said authority is obstructing the adjudication of this matter, which is pending since 2019. Copy of this order. Be forwarded to such and such portrait. Or furnace tribunal, Superintendent Police Border. Oregon. As well as to Mr. Z. Sharma, standing counsel from the department. Mr. Sharma, copy was also issued to you on earlier occasion. What happened? By our earlier order of 2nd of February, copy was furnished to you. It is in the office note. You received on 5th of February. Why the record is not before us?
Yeah.
Do the needful.
Yes, my lord.
May it please your lordship. Lordship, this trial has been filed for seeking effective implementation of section 12(1)(c) of the RTE Act, lordship. And through
Yes, what is the instruction?
Instruction to the deputy commissioner, district office, including director.
When it was issued?
It was issued on 7th of February, this month.
lordship, these instructions, I also have a copy of it. This does not envisage what was there in the last hearing, lordship. In the last hearing, though it's not recorded in the order, this court had specifically and categorically asked the respondents to tell the court about the status of the last year, how many children admitted across Assam, where, what progress, and any inspection done of the children admitted, lordship. There is no mention of development of the portal, when the portal would be ready. Where is the website, lordship, which is one of our prayers, that there should be a centralized website for the education department in the guidelines of the NCPCR guidelines, lordship. And nothing new has been stated in these notifications which my friend has submitted to the court. These are a repetition of what was already there, lordship. May I take lordship, on last year,
Just a minute. Why you have filed this? Yeah.
my PIL is for the effective implementation of 12(1)(c) of the RTE Act, lordship. Through this PIL and through various orders of this court, 44 children were admitted to various private schools after this PIL was filed, lordship.
Right, very good.
Lordship, our first PIL was filed in 2020, lordship. After that PIL, the court had directed for the issuance of the OM, which is at page 39. After the OM was issued, Lordship, when nothing happened in 21, we again filed a PIL for the implementation of the OM and wide circulation of all the provisions of the OM. Then these notifications had come out. Then even after that, when the schools, when we approached on our field survey, informed us that they were not aware of this OM and of the various notifications of the government, then we filed this third PIL, Lordship, which is before this court now. And on the basis of this PIL, 44 of our children got admission in various private schools of the state. But that was only one of our prayers. We have many other prayers in the in our PIL, which are relate to even the NCPCR guidelines, which the state ought to have taken up. My humble submission is, Lordship. Welcome. Where is the staff? Our audience is
Cabinet memorandum to. Ask for a 252. 5.
Mr. Khataniya, what happened with the cabinet memorandum?
As regards the portal is concerned, my lord, it is ready, but it's not live because we are waiting for the approval from the cabinet.
Lordship, that prayer has been there since 1/8/2023. If Lordship will look at the order 1/8/2023, the Education Department had submitted that the portal with details of the present status is underway and sought for 4 weeks' time.
Now it is ready, madam, portal is ready.
Lordship, the academic year starts from 15th of March. Lordship may kindly come to page 43, the activity calendar, Lordship. And in 15 days, it is only 15 days away now. Page 43, if Lordship may kindly come to page 43, serial number 11, activity calendar, Lordship. The events and tentative date is very clearly mentioned in their own OM. Lordship, number 7, if Lordship will see uploading.
Just a minute. Just a minute. Mr. Khatuniar, the order sheets does not reflect a very healthy state of affairs.
Yes, madam.
What kind of submission are you making today? Come to the order of 1/8/2023. Do you have the copy of the order?
That
You
was-
take it out in your
Move on to Kotbul. Move on to Kotbul.
Yes, ma'am.
1(8) second paragraph.
Move on to Session Kotbul.
I have seen, madam.
Please read out.
Mr. R. Mazumdar, Land Standing Council, Secretary Education Department submits that the process for opening the portal reflecting the position of RT admission in the respective schools is underway.
Next. And about 4 weeks
time
is required to complete the same. This was in August.
Yeah.
Come to the next order. After a month, 11(9).
Yes, ma'am.
Sri R. Mazumdar, Learned Standing Council Department submits that online portal for showing status of RT admissions in various schools will be operational within 2 weeks.
Yes, madam.
That was on 11(9). Next, the
Ten-
matter is listed on 10(10). So-and-so Khatunier, you had there, submits the portal has been developed
Yes.
by the department and this file is placed before the cabinet. Same submission you are making
Yes,
today,
ma'am.
developed.
It is-
That was in October. Then again in November 17th, R. Mazumdar, so-and-so submits that this was put implementation of so-and-so. Has prepared a cabinet memorandum for placing before the cabinet. Prior to that, interdepartmental consultations are being sought. He seeks for 2 weeks. Matter again came up on 5/2. You said that the cabinet memorandum is prepared and you pray for 2 weeks time to place it before the cabinet. This 2 weeks is going on and why?
Yes, I have, that I have seen, madam, but it is not approved till date only it is not approved, madam. Though today morning I have discussed with the.
No, your submission you're making today was made 2 months back. How does it make we are not moved by this kind of submission.
Earlier, madam, it was under process. Now, madam, as per today's instruction, madam,
No, how do you don't, your submission does not even inspire any confidence. Same submission has been meeting from months together.
no, madam.
Is being developed, 2 weeks, cabinet. When is it going to be done?
As regards the cabinet is concerned, madam, that is a gray area because I have no complete instruction as regards the cabinet. But as regards.
You sought for time. On your prayer, we had fixed it on 29/2.
As regards the portal is concerned, madam, today morning I have discussed with the deputy secretary and told me that it is ready, madam, and they can do it on. Before getting the approval from the cabinet, they are planning to do.
See, these are not adversarial kind of litigations.
Yes.
We have, they are only seeking an implementation
Yes,
of a statute. You have also said, yes, we are
In fact, it's
implementing.
the-
And it's going on, but when? And March 14th, the admission starts.
From 15.
Don't you think that this year, entire year would be wasted?
Lordship, the children are going to be deprived.
In any case, regarding the admission, madam, we can do it offline also. That is.
No,
not-
Lordship, that is not the issue.
But regarding, for,
When can you get the concrete information? When are you getting the concrete instructions? We'll give you a last opportunity. Otherwise, if you are not being able to get the instructions, we'll get the instructions directly in the court. We'll have the officers.
Yeah. after a week, madam,
Lordship, after a week would be too long. There are only 15 days left now for the
We'll fix a
admissions.
date. On the
on next,
Tuesday,
next,
Wednesday. Next Wednesday.
next.
Six.
Madam, next Thursday, madam.
Lordship,
I have been told that there is cabinet on Wednesday, madam. So if it is placed on Wednesday, then I can.
but there is always a if, Lordship, since August last year, they have been taking the same plea again and again.
If nothing happens on 6th, there is no cabinet, nothing. What prayer you will make on 7th? What will be prayer on 7th?
That is difficult.
Then we'll ask the officers to be here. This statute came when?
2009, Lordship.
We are in,
24, madam. There's nothing, till 2013, there was nothing, madam. In 13, there was a put memorandum, but it was, after the PI filed by Nanda Singh, madam, it was under process.
It moved,
Actually,
Lordship,
madam.
very slowly.
In fact, it is,
so what steps government have taken since 2009 Because it came into force from 2010. Till now, what's there regarding 12(1)(c)?
No, but in 2021, we have issued an OM, madam.
Pursuant to RPI
If
lordship.
somebody doesn't comply with them, it's a mandatory
Yes, ma'am.
provision. Each such school is required to do it. Just tell us, just guess how many such educational institutions are following this provision.
They don't have a data
Because
lordship.
in and around both the banks of River Brahmaputra, we have large number of these type of schools. Just tell us how many. How many might have put?
Today, I don't have that data, madam.
Lordship, it is not available anywhere. It ought to be there in the website, and the website has no information of any kind.
Think over.
Complete failure,
And,
lordship, after the act is
We'll
there.
give you time till Thursday. But if Thursday morning at 10:15 is not available for us, we know what to do. Is that correct? So you have to surrender, saying that we have failed to implement this particular provision. Issuing OM is not sufficient.
Yes.
Whom you have communicated those OMs? Will you communicate it to all those institutions?
Only after our PI, second PI lordship, they sent out the notification to everyone.
Recent instruction that I have placed with the madam. Here also we have communicated with them. Their.
Where you have? How the people are aware of this provision of 12(1)(c)? The school authorities or the guardians are aware of this provision. How you have made known this particular OM, the public? Think over. As you say, on the prayer of Mr. N. Secretary, Standing Council, Department of School Education. Last sons granted to the Department of Activities and the Education Department. Comply with the directions of this court passed earlier in this PIL. Placed on 7th of March. We'll have it on 7th.
Lordship, regarding the activity calendar, that has, nothing is there on record, Lordship. Hardly 15 days to
We know
go.
that.
7 days. Much obliged, Lordship.
May I please, your Lordship? Lordship, the conducting council has some personal difficulty. Lordship, may kindly pass over for the way matter. Lordship, may fix it tomorrow.
Just tell us on which date the petitioner appeared before the Superintendent of Police Board of Borpeta. Pursuant to the order dated 7/10/2020.
Lordship, that I am not able, Lordship.
Hmm?
That I am not able.
Tell us. Get the information. By 12:30, you have 15 minutes. Get it. Let us, we'll call this item again at 12:30.
Keep the Lordship.
Okay. You also get the information.
The record come.
Yes, Mr. Ahmed, tell us, when did you appear? When?
We are regularly appearing. I informed her, we are
Why you
here.
are not supposed to appear regularly?
Monthly he is appearing.
Why? That is not the order of the court.
But the police made a condition that you
Are you
appear
sure?
regularly. Yes, yes. They informed me.
We are regularly appearing, but this case, my lord, reference was made only against the case number one.
Let us see.
So as far as Sudhiran case, others
Let us
can. Only Aravind Vishwas.
Mr. Ahmed, take your seat for a while. Affidavit on page. Page 9. Paragraph 5. Paragraph 5. No, it's paragraph 1.
Must say second petition.
Mr. Ahmed, you are not required to file the affidavit properly in the second copy before a DB.
I'm sorry, my lord.
There is no verification.
My lord,
There is no verification in the affidavit. Even before a single bench, whatever you are filing in the court, it has to be properly done. Affidavit without verification, will it mean anything? And how vaguely it's been said, I am Sanjay Biswas, I am the petitioner, there are 4 petitioners. How is he connected with the others? What is the petitioner number? Last line also you write by hand, I am authorized to take steps on behalf of the other petitioners. No initials, no verification of paragraph.
it is actually petition number 5, my lord. I'm sorry, my lord.
What is the date of birth of the first petitioner?
Date of birth not mentioned.
You have not mentioned anywhere.
No, no.
We have checked the written statement, not mentioned. Neither in the writ petition.
No, but they mentioned his evidence that he was 57 years of age on 26 October 2016. In evidence, he stated.
Page.
Page number 15. 26th day of October 2016, evidence taken 57 years.
Well, that is from 1990. So because borrow for the 59 born. 59 born money, he was eligible to vote somewhere in the year 1981. 90 to 90 level the list nine. First move से कितना? Level move 78 or 1980 कुछ. It is more of the video. Base paragraph 6. Paragraph 6. W. 82 का चलिए 92. Hotel is continuously. So we have some paragraph 7. Paragraph 7. Okay, good. For the first one. Admittedly, there is no water.
No, dish. Share.
70.
No, I think to 81 of the total the student are not able to. From 90 from the community. 80 per doctor. Right. No, 70 interesting. No, each of the police there, not on seven. Not on seven, development.
I don't know. I said.
Your first voters list. Rather, the voter list containing your name, your means the number one, OP number one, petition number one, is of the year 1990.
Yes,
You became eligible to vote somewhere in the year 1980.
but they shifted.
No, 15, but in the earlier place of your residence, you have not
No,
placed
Kali.
no voters
No,
list.
because 1978 we received it,
You shifted in 78.
78.
So shifted to a new place in 78.
No,
Your father passed away in 1980. 80, you became eligible to be, for your name to be entered in the electoral rolls.
no.
From 80 to 90, there is not a single document.
As they mentioned, there is no documents, but
No,
sometimes
we are not under mentioning. From your part, what effort did you take to produce a document from 1980 to 1990? You say 1990 for the first time your name appeared.
yes. In 1990, illusion can be seen.
you-
1990, 27 years.
27 years.
Okay. 27 years.
Ah,
Aravind Viswas.
Eighty-nine also, the total list is there, 89 total list is also.
89 has been
Yes, 89 is 27 years also.
page.
Page 34 and 35.
89.
Here also is mentioned 27 years.
You had an elder brother called Indrajit.
Yes. Ashwini Viswas.
Ashwini also.
Yes,
Can you show any voters list of Ashwini and Indrajit along with
yes,
Basanta?
yes.
Which one?
It is my lord. 1990, my lord. Page.
Prior to that. No, 1990, your father passed away a long time back.
No.
Father passed away when? Father died in 1980.
Yeah.
We are trying to see a voters list of your elder brother along with your father. Because elder brother is aged, one is 45 in the year 1990 and one is 33.
Actually, there, I also mentioned in my details and evidence, they went several distant place. Their houses are also different. And I mentioned page in my evidence of first part.
Whose houses are different?
You also can page 16.
No, whose houses are different?
My brother.
Then how in 1990 your brother's name along with you,
No,
same house number?
1990, but his father name may not enlisted along with the petitioner or his elder brother.
No, along with the petitioner, it may not be there because if
So-
you look at the age of the petitioner, but
Petitioner.
he had two elder brothers. One is
Yes.
Indrajit, one is Ashwini.
Yes, mother.
They are from their age, it appears that they attain the age of franchise. right to exercise the right of franchise,
Yes.
and their names are not there.
In the year of 1945 years, Oshini should have appeared along with his father,
That is the question. you are
89, but
putting.
he's not here.
Seventy-eight percent. 70 to the aim. I couldn't get it. I don't know from India. Mr. Ahmed.
Hello.
What my brother wanted from you. What stopped you from producing the voter list of 1970 and thereafter, along with your brothers Osini Biswas and Indrajit, with your projected father Bakhanta?
Because at that point of time, my lord, they could not procure all the voter list because those are not available.
Maybe.
They don't
maybe,
know,
then-
but urgently they need
No,
to file
That is fine.
written statement.
This
COVID
repetition
problem
was filed
was
when?
there.
This repetition was filed when?
2019.
Order of the tribunal was passed when?
Order of the tribunal passed, my lord,
2019 January.
19 January.
Who stopped you producing all those materials? We annexed with the repetition. You are not there.
Because they could not gather information whether then appear.
For addition intelligence. बोलना है order से तो खाली बची है पेज नंबर 2 है ना फर्स्ट पेज में 9 से खाली है 18 19 okay फर्स्ट पेज to 9 অপকৃষ্ট হাজির হয়ে ৪৪৪ হস্তযোগে প্রয়োজনীয় কাগজপত্র দোকান মুখামুখি দেওয়ার দেখা দিব নোৱাৰিল 22/13 নোটিশ দিছিলে তোমাৰ 19/4 22/13 সেপ্টেম্বৰত ৰেগুলেশ্যন ফাইল কৰিছিল ইয়াতে কোৱা হ'লে ইয়াতে যদি কাটি দিলে, New document that you have. I have from the account of the previous. Fine. See, we have checked from the records. You first appeared in May 2013. And the written statement has been filed on 18th of September 2023.
20?
Sorry, 2013. You had around 4 or 5 months.
Because my lord, at that point of there, everyone is not thinking about those. Then whatever documents they got, they immediately collected and filed. Moreover, my lord, in some, at that point of time, the authority also gave voter list only by name. No other persons, my lord.
Have you stated that you had voted? Okay, you don't have the document. Have you stated in your written statement or in your deposition?
No, it's not.
In fact, in your written statement, you have said that your name appeared in 1990 for the first time. It's your version. You come to page.
Yes, I have seen. I have seen, but there is exhibit.
Paragraph 7.
Yes, I am. But on exhibit 1989 voter list has been exhibited, my lord. So, my lord, although some name of the petitioner also appear along with his brothers, and moreover, my lord, if you'll also give me some time, I will try to collect whether there is any voter list in between 80 and 90, my lord, along with his brother.
It is pending
Let
since
some time may give him.
it is pending since 2019, 5
Well,
years.
5 years, there's a problem, but cases are not listed. Thoroughly,
So you will not
cases
take-
are thoroughly cases are listed.
So you stay very cool. Cases are not listed.
My lord.
Now cases will be listed.
I will produce, my lord, sometimes may give him.
You are not too not too convinced.
But 89 voter list, listen, apart, suppose my elder brother's name not appear in the other voter list, but since my voter list has been appeared for the first time in the 89, it is proved that I am the son of Basanta. Basanta name has specifically mentioned in the 89 voter list.
See, this is a Vasanta of a different village.
No, I mentioned that we
But
were shifted.
the shifting, how have you proved the shifting?
Because,
What are the other documents?
because shifting, we laid evidence, my lord, they are not controverted.
Let us see your
Philosophical is
evidence.
a cause, my lord, they are not controverted.
Let us see
That
the
is not
evidence.
required.
Let us see the evidence.
That is not required.
No, yes, they should controvert, my lord. They should controvert, they should damage our evidence. As per hydraulic case and fundamental case, all the cases mentioned, they should, once we burden, prove our burden shift to them to controvert.
Let us see your evidence.
Yes, my lord, philosophical say page 17,
17.
page 17. I am OP number 1 incident case, OP number 2, menu discharge in my wife. Other OPs are my children. I have filed detention on received notice. I am born at Jangaipuri under Borogora PS, but parents shifted to Malbota for livelihood.
When?
They casted vote in Jangaipuri, my lord.
When did you shift?
No, written statement we mentioned 78. Written statement we mentioned 78, 1978. And all those documents were exhibited without any objection.
Directly.
All those documents were, my lord, exhibited without any objection. And moreover, that they have been not cross-examined, they have been examined by the court.
No,
The court they examined.
we have seen in many matters where in absence of GP was not there. So member had put, court can put the question, that's not.
Well, then we're correct. That is why in some cases I place those judgment. That is why in some cases this humble court revert the matter to the tribunal below for cross-examine them by the pleader, court pleader. I will place those judgment also. Several cases has been referred for allowing the government to cross-examine the witnesses.
Mr. Ahmed, you have referred to documents which you have marked as exhibits A to J. For the time being, let us not doubt the correctness or the genuineness of the documents.
Well-
But which document will show a linkage between you and Basanta? Show us
It-
the document.
Well, 89 voter list and my evidence.
Yeah,
Whether my
no, no,
evidence has been
document,
denied.
Document.
Documents, well, 89 voter list.
89 says.
Name, so son of Basanta. Sufficient proof is there, my lord. And Governor has also issued certificate, but Governor not examined, but Governor also issued certificate.
You know the law
Yes.
of certificate.
But 89 documents cannot be discredited, my lord, because it is nowhere that I produce total list of someone, my lord. We written estimate, we specifically mentioned that we shifted. And that 89 voter list, 90 voter list also in shifting place. And when we specifically mention we shifted, they are not question it, they are not disputed it, my lord. They should have disputed it, my lord. And moreover, a tribunal cannot pass such an order that one line documents cannot be accepted without giving any reasons. Exhibit A and B did not consider only on the ground that single name has been appeared. This is the ground. Even my lord did not give any suggestion that I am not the son of Basanta. No such suggestion has been given. Telephone number to
Read para 5, 6, and 7 in your written statement.
Similarly, the name of Basanta Biswas, son of Passionate Biswas, the father of Wazir number 1 has been enlisted as voter list in the list of 1970 under Swensu, Assam, House number Swensu, Jangaipuri, Swensu. that subsequently the father of the opposite party number one has been shifted his residence along with his family members to present address at so Marigaon in the district Marigaon, Assam so due to his family separation in the year 1978. And thereafter, in the year 1980, father of the opposite party number one was died, and name of the Basanto Bishas, son of Kasinath Bishas, the father of the opposite party number one, has not been enlisted as voter at present address of the opposite party. And seven, the similarly the name of opposite party number one name Aravind Bishas, son of late Basanto Bishas, has been enlisted as voter in the voter list of 1990 under Swenso, Buragao, Malputa, Morigao, Moza, Swenso, for the first time.
Come to your deposition. In your cross.
For us, he stated that 1972 his
Read,
father.
read. I have
I have two
brothers.
brothers, Osini and Indira, and they are settled at Malkota, Indira, and Osini at Kedajan. My grandfather is Kosi Vishas. Father expired in the year 1972. Mother Babli Vishas expired prior to my father's death. Father did not have landed property. I have no any paternal uncles. Indira's wife is Nilu and Osini's wife is Loni. One brother, Nobi Vishas, has expired 1 year back. I have no brother-in-law, Robi Malu Christi.
So why this family separation? You do not have uncles. Why this family separation?
Family is amongst them, my lord. Amongst them. There, some of remain there and some come here.
Who?
His father.
You said fathers have no uncle. You do not have uncle. That means your father doesn't have any brothers. Then why the question of family separation? In your written statement, you said your father expired in 1978. But in your oral evidence, you said expired in 1972.
Yes.
If it is so, then who is this?
No, that family separation has been between his grandfather.
Please come to page number 37.
Grandfather, my lord. Yes, my lord.
Who is this Noni?
Known is
Is it
the
about 77 years?
wife, my lord.
Is it?
Wife of Osini, her
Hmm.
Osini Vishas.
Then what you have said in your evidence?
Osini Vishas, 70.
Indira's wife is Nilu and Osini's wife is Loni. Now you are asking who is this Noni 77 years old lady?
My lord, one voter list I found. My name appeared in 1927 and 1927. How, my lord? So there is a mistake, some mistake is there. Because illogistically it is apparent, it is proved that in 1989 voter list, my age has been recorded 27 years. In 90 also 27 years, my voter, mine as mentioned. Which one is correct, my lord?
That 1 year discrepancy, you cannot really compare with a discrepancy of this nature. You say Osini is your brother. In the voter list of 1990, the age of Osini has been shown as 45.
Yes.
Then comes Noni. She is the wife of Osini. Her age is 77.
It is
actually-
apparently it is wrong, my lord.
No,
It is
Noni is not your mother. You said your mother
no,
passed
no,
away.
no, Babli.
Probably before, just before your father.
Yes.
So in 1990, name of your mother would not come.
Yes.
Have you stated that her name or the age was wrongly written?
Those are not mentioned. Those are not
Did you
mentioned.
write
But-
it? Did you state in your written statement? Yes, there is a voters list, but the name, but the age is wrongly written.
It is not written.
Because if you project her to be your sister-in-law, the
Yes.
wife of your elder brother,
My lord. Because in a written statement, even we have not mentioned the name of our family tree. Family tree stamp we are not
Okay,
given.
we'll come back. All of it. Mr. Ahmed,
My lord.
page number 35
Yes, my lord.
or page number 37. And these are of course in vernacular, otherwise also 35,
Yes,
34 and
35.
36.
Yes.
Ashwini Biswas, Indrajit and Aurobindo.
My lord.
That includes the petitioner. Son of Bokhanto. Voter
Yes.
list of 1989 and 1990.
Yes.
Right?
Yes.
Ashwini Biswas was 45 years.
My lord.
I thought 1989 or 1990.
My lord.
So his date of his birth year will be sometimes in 1966,
My lord.
1945,
My lord.
right?
My lord.
And adding 21. So he was eligible to vote from 1966.
Oshini.
Ashwini.
Yes. My lord.
Now, next one is Indrajit. Next one is Indrajit. So in year 1990, he was 33 years old.
My lord.
So his birth year was 1957. So adding 21 to that, it becomes 1978. Is there any voter list from 1966 till 78 showing Bokhanto along with Ashwini Biswas?
No.
Showing Bokhanto along with Ashwini Biswas? Is there any?
Here.
You have failed to place that before
Yes.
the tribunal,
Yes.
and thereafter producing this 1989 or 1990 voter list, showing this Ashwini Biswas with Aurobindo.
Yes.
Link could have been proved
My lord.
that this Ashwini Biswas, along with his projected father, Bokhanto, had cast vote earlier in 70 and thereafter.
It is not mentioned.
They have not said anything.
No.
You failed to place all those materials before the tribunal,
My lord.
right?
My lord.
You could have proved your link that way also, but there would have been no requirement of such certificate from anybody else. But you have failed to place all those materials before the tribunal. Right?
My lord, only question, my lord, at that point of time.
At that point of time, even after the order of the tribunal, you could have procured it and place it by filing appropriate application before the tribunal.
But here, if you logically say 1989 voter list,
Just a minute. এই voter list can be
এখানে village fund very Buragaon. এখানে 789.
দেখেন,
তো এখানে 78 হলে
ভোটার লিস্ট করতে নয়,
we can signal the asset.
ভোটার লিস্ট করতে নয়।
One more thing I'll just point out,
No, I will come, Mr. Mittal.
because brother's name
No, we'll come.
haven't been stated.
मैं कोई लो
The person, I mean,
लोग कोई लो
Mr. Ahmed,
Hello.
your projected case is that in 78, you had shifted to a place called Malputa. You have annexed certain voters list post 78. One is 89 and one is an additional voters list. It's not 90 voters, it's an additional voters list.
Yes.
See the vernacular and see the name of the village here.
Page
Page 36 or 37.
37. Yes,
What is the name of the gaon?
name of the village, my lord.
Burha gaon.
Buragaon.
Where is Malputa here?
It is called Malpota, but the revenue village is Buragaon. It is revenue village.
Now, why didn't you then say
Sometime,
that, now you could have said that we have.
sometime is area wise they're given
No, you
some.
could have shifted, you could have said that we had shifted to a, of a
No,
village
Douglas-
called Buragaon.
Douglas mentioned, Douglas it is mentioned. Buragaon mentioned. Paragraph 7, in WS it has been mentioned that we shifted Buragaon, within bracket Malpota they are written.
No, within bracket is Buragaon.
No, yes, I said it.
Two places differently it was written.
You could have easily said we have
Yes,
shifted to
yes.
Buragaon, matter is there.
My lord,
Voter list. are
paragraph
Buragaon.
7 of written instruction,
Page,
page 12.
yes,
Paragraph 6, it has been mentioned Malpota, Buragaon, within bracket Buragaon. Page 7, paragraph 7, village Buragaon, within bracket Malpota.
in the paragraph 6, you see village.
Yes, yes,
Malpota.
paragraph Malpota, within bracket Buragaon. And paragraph 7, Buragaon, bracket Malpota. It is written. But another thing, my lord, let's look at 89 voter list, my lord.
Malpota is a different village.
Malpota under,
Buragaon is a different village. One village cannot be under another village. One village can be under some other bigger area.
at
Or a
that,
part or
at,
something.
at that time, it was fall under Nagaon district. Nagaon district. 89 voter list, my lord, Nagaon district mentioned. If you look at voter list 85, page 85, 35, my lord. Here also age of Ashwini বিশ্বাস, written 45 years.
When was Morigaon created?
I have no idea.
No, see your written statement, paragraph 6. You have stated with district Morigaon, not present Morigaon.
Yes.
Not only PS, it is the district also.
Hmm. In 66 voter list, it is also mentioned district Nagaon. But your lordship kindly see page 35 for a moment, my lord. Age of Ashwini বিশ্বাস is 45 years. 89 voter list. Again in 90 voter list, 45 years.
That is the additional list. We have pointed it out. It's the same list.
So,
See, it's the additional voters list.
your lordship kindly see page 35, serial number. Your lordship kindly see
Yes,
serial number 1501,
yes,
Ashwini বিশ্বাস.
yes.
1502 not given.
That is why it is the.
Not given, my lord. And 1204 not given. Rotary has supplied it, my lord. Two name has been missing. They should have mentioned all the names, my lord, serially.
Additional.
See the vernacular at 37. What is the heading? It's Poripurok.
Additional.
It's Poripurok. There is no change.
Puripurok Kalika.
Yes,
Yes.
because it seems that some names were left out, so those were inserted.
Like Noni.
Noni was not there initially,
Nilu was.
only Ashwini, Indrajit and
Yes.
Aurobindo were there. Now Noni and Nilu have been inserted.
Inserted. So, and
That is why there is no change in the age.
yes. Come on, give me one chance to clarify whether their name appeared, Bharat's name appeared in between 78 or 90.
Put the bill different. No, put the technique different. Compared to that. Right. Mr. Kolita, both Buragaon and Morigaon district and Malbuta, two different villages in two different revenue circles. It's there in this available here only before us.
Lots.
Nothing yet to see. Completely two different villages
Then everything goes like,
and two different circles. That's more important.
everything goes, everything collapses. Lots. Otherwise also lots of, as far as the brothers are concerned, he hasn't stated anything about the brothers in the WS. Nothing. Only when he was crossing, I mean,
And if what my elder brother was asking, Ashwini is declared as is 45 in 1990. So he became eligible somewhere in the year 1966.
so there should have been some voter list.
Father died in the year 1980.
Yes.
At least one voter list, not with the petitioner, but with his elder brother along with his father.
There also lots of, as far as death is concerned, father's death is concerned, he's not sure whether his father died in 1972 or 80. The two specific statements have been made.
Where?
In WS, he stated that his father expired in 1980.
80, right?
But evidence,
In evidence part, Lordship will find in the questioning.
72.
Yeah, Lordship has already pointed out 72. So he is not sure.
Page,
Whether, page 16 here, Lordship, the translated version.
Within statement of 78 village.
let us see the vernacular.
Yeah, vernacular Lordship will find.
Here,
Yes, father expired, it's 19, page 19.
Yes, Lordship.
72.
At the age of 19. It's very clearly stated that 1972. So that really casts a doubt whether this person was really, the projected father was really a father or not, because he's not sure when his father expired. And Lordship, if your Lordship notices one more thing, that is the Gambura certificate. Though that is not proved, it was not proved. That is page 47 here also. So that's again a different village.
something is wrong here.
Royal
Let's come to page
What?
39.
Page 39. Yes, sir, Lordship.
On the right side,
Yes, Lordship.
Morigaon town,
Block so and so.
block 2, Buragaon.
Yes.
Then block 3, Roina Potter. Block 4, Malpota. Block 5, Stadium Elephant. This is within Morigaon town itself.
Yes, Lordship.
Though these are, whether it is Malpota or Buragaon, probably we don't know. But what we have to see here is this particular voter list. Block 2, Buragaon, Block 3, Roina Potter. These are the within Morigaon. Block 4, Malpota, Block 5, Stadium Elephant.
Yes, Lordship. That is there.
But anyway, the procedure failed to place all these relevant materials to link his father with him.
Absolutely, Lordship. Absolutely.
in 97.
When did you get married?
My lord,
The OP number one, the petition number one?
OP evidence.
No. Your petition number one. When did you get married? Marriage.
It's up to the board of They will not be affected. Nothing. Reference.
The Kolkata on the aspect of the other petitioners, no reference.
That lordship, that's a settled position.
Without there being a reference.
What about the children?
That's, I mean, that cannot be.
The children,
Yes, children also. So there is I mean, if the father is declared as a foreigner, so obviously there is I mean, we'll have to presume that, so that's why there have to be some references. Some references has to be there. There is a settled law that has been settled by this honorable court only. So without reference, that cannot be done. So fresh references has to be issued against them. So that is settled in one case, lordship.
Sudhir Roy.
Sudhir Roy, yes. In paragraph 9, that has been specifically handled. There is some-
Regarding as my lord. Itu namun dasar. Itu namun dasar. Namun itu apa namanya dia? Itu. Itu. Asal tahu.
So you have seen that reference, initially the case started with the petition number 1.
But the
Report inquiry-
inquiry is regarding all the members.
Initially process was only with the petition number 1. The reference is also against the petition number 1
Yes, Lord.
by the SP Bureau.
Yes, Lord.
But however, the notice was given to all by the tribunal.
Because of the this
No,
inquiry,
that was not the reference. That was the reference of the SP Bureau is very specific with the petition.
yes,
Sudhir Roy takes the consideration Aktara.
Husband get away.
Aktara says that yes, you can draw up presumption for the
yes.
family member, but that by itself will not dispense with the requirement of a reference.
The reference.
Aktara has not been reported, no? Aktara is also judgment of justice, Mia.
Yes.
Hello, da.
Yes.
I want to refer WBC, my lord. WBC number 2926/2019,
On what point?
para 4 regarding discrepancies of age
2926.
/2019, para 4. And my lord, this court held that different age is not a significant.
2926.
Yes. 2926/2019.
And the name?
Talibur Rahman Talomunsi.
Talibur.
Talibur Rahman Talomunsi.
Taliban. P.A. Rahman. What is the proposition?
Court, sir. Well, the discrepancies of the age will be no significance if other parameters in evidence are similar. And another one is, my lord, Motiur Rahman, Indian other, reported in 2021 GLT,
2020.
21 GLT 330 regarding discrepancies of name, age, and address.
Of name.
Name, age, address.
Those are not material.
No materials are other, yeah, this, and this has been a Sirajul Haq case, my lord. Sirajul Haq case, my lord, reported in 2019 5 SCC.
Kematullah Kafarullah.
Kamatullah Kavatullah.
MNF.
Yeah.
Grandfather.
And regarding the shifting also.
It's a grandfather name,
Yes,
where M was replaced by F.
yes. There also mentioned age and shifting part also mentioned. that-
But Sirazul was on a very specific issue. Where grandfather's name in place of M, F had come in.
Man.
Honorable Supreme Court has said that these matters perhaps can be ignored because it's basically grandfather only one letter alphabet
Man.
is changing. But that will not have an universal application. Where there are discrepancies which are major, glaring.
But regarding this shifting part is there.
The Lordship, these things are not insignificant. There are no significance of this issues in this case, Lordship, because the link is only failed. There is no link he could establish. Only when there is some link, then there are some discrepancies, then it may be relevant. But otherwise, there is no relevancy of this.
Purita, you will have a point, because first you have to surpass the first hurdle.
First,
Establish a link, and in the linkage, if there are
Yes, Lordship, otherwise that.
But link,
which appears to a reasonable mind, that
But,
can be ignored. That is.
so far as the link is concerned, in this case, we found that 37, sometimes 40, even sometimes I got 39 in the voter list. It has been found. So that is not significant. And in the voter list, in last column, it has been mentioned anomanic experiment, not accurate as has been mentioned.
Mr. Ahmed,
It has been mentioned.
we'll come to the discrepancy, provided you can produce one document
Link.
to show the
No,
link.
link, my evidence is sufficient. My evidence not has been disputed, my lord. That will be observed. My evidence not been disputed,
No,
not suggestion has been given,
We-
and the 89
we'll
voter list,
definitely-
90 voter
We'll
list.
definitely consider your
Yes.
submissions.
Because
But
my
your
evidence has not been
submission-
discarded.
Your submission needs to be tested with the law laid down.
Well,
Whether oral evidence,
Yes.
in absence of any documentary evidence, which are supported by contemporaneous records, those are the expressions. Whether you pass that test.
no, it is also there, and evidence of 1950, 1959, 60, my lord. Mention, oral evidence must be considered. Oral, judgment also there, I will place that judgment also. Judgment is there. The oral evidence must be considered.
Oral evidence, as per the Evidence Act, is definitely, it's a mode of evidence. Oral, it can be documented, it can be electronic, anything. But in the Special Act, where Section 9 has an overriding effect, because it's got a non-obstante clause, because notwithstanding anything in the Evidence Act, and the settled law from Fateh Muhammad, Ghaus Muhammad,
Yes, yes.
Constitutional bench has said the burden never shifts. It's not a question of shifting the burden. And rebuttal evidence would be necessary when only you surpass the test of reliable, cogent, and acceptable evidence.
I think it is mentioned in the Swamananda Sunwal case.
Yes,
Burden
you
is
are correct.
shifted to them, my lord. They should later on. After our
No,
burden is over,
burden
then it is
no,
their
no,
duty
sir,
to rebuttal it.
Sarvananda-
Hydraulic has also
Sorry.
specifically mentioned.
Mr.
Hydraulic.
Ahmed Sarvananda Sinha has never said that burden would shift. The provision of law is
Yes.
that there would be a requirement, if they think that there is a requirement
Yes.
to adduce evidence on behalf of the state.
Yes, my lord. Then another judgment, my lord. 2021 3 GLT, 21 3 GLT, 85,
85. Name,
Hydraulic versus Union of India and others.
HAI.
SAIDR. Para 24, 26, 27, 29, 33, 39, 40, 42, 46. Clearly mentioned all the things, all the question has been answered in their judgment. Another judgment, my lord. 2008 Code SCC 75, page 75,
For SCC,
Core SCC
What is the proposition there?
75, para 26,
name,
27,
name,
name Ben Singh and another versus
DAIN,
BANT.
Band.
Bant Singh and another versus Niranjan Singh. D.
What has been stated?
Here,
Write down.
here, my lord, I given my oral evidence that I am the son of so and so. My wife also given evidence that he is my husband, so and so. But as per that part has not been considered by the landed tribunal at all. No finding has been given regarding my oral evidence. Whether my evidence accepted or not accepted. And same view has been taken in another case, my lord. 2008 4 SCC same, my lord, page 520. Tulsa and others.
Tulsa,
Tulsa.
TO,
TULSA. Tulsa and others. Versus Durga Tia and others. And those judgment has been followed by the decision of the Honorable Supreme Court, my lord, AIR 1959, AIR 1959, SC 914,
name,
Dol Govindo Parisa,
DOL,
DULGODINDA Parisa versus Nimai Saran Misra. Regarding relationship has also been there.
Bunching.
Refuse on Govinda.
Yeah.
Yeah, 1959.
You can say to some.
Nothing to do with the or relevant component.
Lordship, as far as oral evidence, there's cases, Lordship, already there, before your Lordship. As far as oral evidence is concerned, Lordship has already said, my Lordship Justice already said. So that is already there. Ohavali's case, Lordship.
Yes. What brother has pointed out with regard to section.
Yes, Lordship, there is specific act.
Foreigners.
Correct. It's specific. Yes, special act.
Constitution bench and the subsequent bench of the Honorable Apex Court and have also been followed by our High Court earlier. Because that's there is a specific provision.
Yes, Lordship. Yes, Lordship,
The
absolutely.
other matters which Mr. Ahmed has placed relates to civil suits, partition of.
Yes,
parties.
yes.
So those are, they have nothing to do with section 9 of the,
Yes, section 9 is not there.
that has been clarified in the constitution bench judgment.
Yes, yes.
They are mixed. Petition. Polita. Hello. Here you go. It was called by order 0 from the council for next time. Hearing counter order. Hearing.
Item number 1. Mr. Sharma, instruction.
Lord, as per my instruction, Lordship, on 21/10, petitioner has appeared. 21/10/2020, Lordship.
Petitioner appears.
Yes, Lordship. And on the same day, he was granted bail.
My lord, in this matter, actually, the local council of Borpeta has expired. And therefore, we are unable to coordinate with the petitioner.
Records are here. And will accordingly consider in the next. Records are here. If you want to go through in presence of the standing council from the parliament.
Next week, we have been commencing from 11. Hearing. Hearing. No.
Item number 14.
Mr. Chakraborty, in last order nature, it has become infractual.
Yes, my lord. Lordship may take my affidavit. The original writ petition was filed against an order of CAT, whereby the claim of the petitioner for promotion to the next higher grade was denied because at the time of promotion, one criminal case was pending. Now, my lord,
Affidavit filed when?
my lord,
When did you file?
this affidavit, my lord, is dated March 2023.
Shown by one Asutosh Yadav.
Yes, my lord.
Just a minute, just a minute. Yes, where you have pointed out.
My lord, lordship may come to paragraph 3. The special judge in special case number 1 of 2018 has convicted the petitioner and sentenced him to undergo simple imprisonment for 5 years and to pay a fine of 1,000, and in default of payment of fine, simple imprisonment for another 6 months under section 8, read with section 13(1)(d) and 13(2) of the PC Act. Now, my lord, pursuant to this order, my lord, lordship will see that he was imposed the penalty of compulsory retirement, which your lordship will find at paragraph 4. The disciplinary authority on consideration of the attending facts and circumstances had imposed a penalty of compulsory retirement from service by the order dated 18/12/19 under Rule 14(1) of the Railway Service Discipline and Appeal Rules 1968. And that order has not been challenged, my lord. No appeal, nothing, my lord, to our knowledge. So, my lord, the petitioner has in the meantime has been inflicted the penalty of compulsory retirement. So,
What is the conviction order of the CBI court?
my lord, the order is of imprisonment for 5 years.
The date,
My lord,
date,
date, my lord, is 27/2019.
2020,
20.
and followed by a compulsory retirement in the DP or by 18/12 to 19.
Yes, my lord, 18/12/19.
It's not on the challenge.
Yes. And okay.
I am on behalf of Mr. A. Chakraman. My senior is not well. He came in the morning, my lord. Due to some chest congestion in his stomach, my lord, he went to hospital. He came in the morning.
It
In
is
the
okay,
middle.
but is there anything, there is no life cause of action to be adjudicated. He has been given the penalty of compulsory retirement, not challenged.
Yes, ma'am.
Now, this particular writ petition was against an order of CAT,
Yes, ma'am.
whereby your claim to promotion has been negated. Now that has become infractuous.
I don't have instruction regarding this, my lord.
We wanted to close this.
Okay. Let him come, the
We have it, we'll have this tomorrow.
My lord, tomorrow I'll not be,
No, we have heard you.
my lord. Tomorrow I'll not
That's
be
about
very.
it, because only he'll have a word with your, he's the senior.
My lord.
See, unless you challenge the compulsory retirement order,
yes, ma'am.
successfully challenge, then your question of consideration for promotion might come in. Now it is, that chapter is already over.
And the challenge to the compulsory retirement
That
order,
was of 19, we are in 2024.
Yes, ma'am.
my lord. Yes,
20, almost 5
and
years
the
have passed.
order of compulsory retirement will also be dependent on the appeal. criminal appeal because his conviction, he has preferred an appeal, he is on bail, that is a different thing.
We can also give the liberty if fresh cause of action arises. In case he succeeds first in the criminal appeal, then he challenges the compulsory retirement, succeeds, then this retrospective promotion or whatever. What is his age?
No, 52.
That I do not, I mean,
He'll be
Yes.
around 52. 52.
He was 47 in.
What? Yes. Maybe.
Have you understood the implication?
Yes, madam. I will
You
convey
have
to
a
my
talk,
senior.
talk with your senior and
Yes,
come back tomorrow.
Yes, madam.
Ask him to appear at 10:15.
Or if he, even if he's not there, get the instructions from him, that this is the, what has come from the court.
Okay, madam.
Petition. List. Mr. Arthropogoti, respondent, the day is.
Yes,
Talking for which matter?
My lord.
You're for which matter?
I for 4 and 5 votes.
Today this bench is going to rise early. There's a full
I'm
bench.
told. Lordship. In that case, Lordship, it will be posted after 18th of March, Lordship. I will not be here in between.
That symmetry.
Cemetery matter, Lordship.
Next week, is it possible?
Or next week I'll be here, Lordship. From 11 to 16, I'll not be here. So, it will be better Lordship, after 18th, after 16 is taken up.
I think last time some urgency was expressed on behalf of the state.
Yes. State is here, madam. State has, I don't think so. Last time state has. State doesn't- And
What is there in priority petition?
We have the record from 1951. From 51 to 1986. It was recorded in history.
Thereafter,
Thereafter, in 2005, Portal Land, number 181. It was for a public utility, public purpose. And that number 153, the reserved for a heritage site. That was the pursuant to the order which you have disputed. Which changes have been done? Revealed from the record.
then
Now this is a stage, my lord, that the construction of one and all, the GMDA one time allowed them to construct one.
No.
Then demolition order. That's the way, my lord, lordship may hear the entire matter, my lord. It will take time. It will take-
Lordship, may I submit lordship?
Original order to work.
May I submit lordship?
You're for,
I'm for item number 5, lordship.
there are two items.
Yes,
Two
lordship.
items.
One is writ appeal and one is writ petition. Both are analogous matters, lordship.
And in the writ petition, government has not yet filed affidavit.
Both are with analogous cause of action. Same
Yes,
cause
my lord,
of-
the affidavit filed in the writ petition, in the writ appeal, my lord, the stand of the state is all along.
No, the petition was in the
Ma-
appellant.
Both are parting the same set of
Challenge
land.
the
Affidavit
impugn
is there
order.
in the writ appeal, my lord.
May I submit lordship?
There is a writ appeal, there is a writ petition.
In the
Yes,
writ
lord.
petition, my lord, original writ petition, there is an affidavit,
No,
My
we are
in-
not on the affidavit.
my lord.
Who's the appellant, who's the petitioner? Are they with the similar, same cause of action?
No, that is different. I have challenged the impugn order dated 2021, lordship, which is a subsequent order of the deputy commissioner. I have challenged in my writ petition, lordship.
We are the residents of the locality, I stand up.
Mr. Kotok is the petitioner in the original case.
Originally, Lordship, where I filed a writ appeal, Lordship.
Yes.
Right.
What was the challenge?
That was this, in 2006, Lordship, this land was suddenly closed for further burial and declared as a heritage site. That they have challenged it. And by virtue of the impugn order passed with the honorable court, it's going on. There.
2005 sort of.
Cemetery is running, Lordship, as a
Even if the reply is not.
That I have stated, that I have said, I have stated.
Mr. Bora, have the records, we have it on 19th.
Lordship, meanwhile, government may file reply to my writ petition, lordship. They have not yet filed the reply, lordship.
If your affidavit in the data is.
Yes.
You get the records. The record is, see, it's open for you to file an affidavit, but that's, you're right. But if you think that the record would do your purpose, serve your purpose, then produce the entire record.
The position of the status of the land, that is already in the record.
19th.
So right, because brother is having a full bench.
Yes.
19th, no?
But shall I keep the record till 19?
Keep it with you.
19th of March, obliged.
Just from 19.
Tuesday.
The state council surplus the 11 records. 11 land records. Pertaining to land, 11 records pertaining to land involved in this. The state may also file its affidavit in WPC number
671021.
21, it's advice.
The land record may be,
That you keep it, we are not keeping it.
no, look, see,
On that day, then produce the records that we have seen.